Hello and welcome to A Bit Too Much to Think. Today is the third episode in a series about sovereign citizens. And basically, what is it that the sovereign citizens are saying? What does it actually mean? And we basically come to the conclusion that sovereign citizens are pretty much always wrong. Now, you may be asking yourself, what are sovereign citizens? They're essentially a group of people that consider themselves beholden to only certain laws and that other laws don't really apply to them. So, one video I recently saw is that some sovereign citizens were claiming to be Article 4 free inhabitants under the Articles of Confederation. What they claimed, and I've actually seen a few different sovereign citizens claim to be this, but what they claimed in this video is that you're a citizen and you get all the rights of a citizen of that state, but you're not beholden to any of the laws. So, let's talk about it. Let's kick it off with what the heck are the Articles of Confederation. So, if you were sick during this day in third grade, or you're not familiar with U.S. history, maybe you're from somewhere else, the Articles of Confederation were an early attempt at a constitution. It was basically a treaty between the states and an understanding and an agreement between how the states should interact with each other, before we had like a real federal government. So, if a sovereign citizen wants to be an Article 4 free inhabitant under the Articles of Confederation, we have to discuss, is the Articles of Confederation even law anymore? We basically know that the Constitution replaced it, so we know it ceased to be law. But the question is when, and this is where I go to scholarship here. So in the Notre Dame Law Review in 2002, a very well-published scholar named Vasan Kasavan, I probably mispronounced that, so I apologize, basically comes to the conclusion that it's either in 1788 when the Constitution was ratified, or in 1789 when the Congress and presidency became a thing. The reason that this differentiation is important, and that's kind of what the rest of this paper is about, is there's a few court cases regarding contracts that were made after the Constitution was ratified, but before Congress and the presidency became a thing. So it depends on the contract law, and that depends on whether or not you're respecting the Articles of Confederation or the Constitution. But in this case, it's irrelevant because no one except for vampires are alive in 1788, and we don't trust vampires at all. So the author then looks to the Federalist Papers, and the Federalist Papers are a series of essays written by Alexander Hamilton, John Jay, and James Madison on why we really needed the Constitution, especially above and beyond the Articles of Confederation. And the author points out that the Articles of Confederation were basically ignored at this point according to the Federalist Papers. So Federalist Essays number 41 through 44 discuss what powers the Constitution actually grants to the government. And in Federalist number 43, James Madison kind of addresses the question because the Constitution only needed 9 states to ratify it. And how is that valid if the other 4 don't, and then the other 4 are still beholden to the Constitution? And he points out that it's the absolute necessity of the case. That's his words. Why is that? Because the Articles of Confederation were basically useless at that point. He then goes on to point out that the Articles of Confederation were not really respected, and while they had some value, no state was really taking it seriously. Now, if James freaking Madison, one of the most important founding fathers, the 4th President of the United States, thought that the Articles of Confederation were invalid at this point, then the Articles were probably pretty invalid at this point. Now, that's 1787 or 1788, so we can say it goes back even further that the Articles are illegitimate. But there's one more point worth making here, and it's, okay, some sovereign citizens do argue that the Constitution lacks validity because there was no legal standing to ratify the Constitution under the Articles of Confederation. Therefore, the Articles of Confederation never actually stopped being law. So in that case, Article 4, free inhabitants, could still apply, right? Well, here's 2 reasons why that's wrong. The first reason, and this is in Madison's words in Federalist 43, the express authority of the people alone could give due validity to the Constitution. It's based on the principle that the people give the government power, not the government doesn't give rights to people. And that's what the entirety of the United States is founded upon. But he also points out that as a treaty, the Articles of Confederation not being respected, in his words, authorizes them, if they please, to pronounce the compact violated and void. So basically, the states have the right to say that the Articles of Confederation don't really apply anymore, and that's exactly what they did by ratifying the Constitution. But there's a second reason that the Articles of Confederation lack validity, And it's because the United States law system is a common law system. Essentially, our system differs from most European law systems, except in the UK, because the European law systems are based on a system of codes. It's called a civil law system, and what the codes say goes. But in common law systems, precedent in judicial decisions are extremely important, and the rule of judges is what matters. It's basically because in the very early English times, like we're talking like 1100 AD, judges didn't even base their decisions on any written laws, but on the accepted legal norms of the time, and really what it allowed for is for communal feelings of justice. Now, we get our law system from Britain because we were British colonies, and so the doctrine of stare decisis, or let the decision stand, is a very key aspect of our law. It's essentially what allowed for Brown v. Board to completely overturn Plessy v. Ferguson. So if no one listens to the Articles of Confederation in our law system, they're not really law anymore anyway. But, okay, so we've been talking about why the Articles of Confederation aren't really legitimate anymore, but what does the Article 4 actually say? Let's pretend that they are legitimate and that you can still operate under them. What does it actually mean to be an Article 4 free inhabitant? Well, it does say that free inhabitants get the rights of other citizens of those states. They're correct in saying that they do. But they're wrong in saying that they're not subject to any of the laws, because it says that free inhabitants are subject to the same duties, impositions, and restrictions as the inhabitants thereof respectfully, and if any person guilty of or charged with treason, felony, or other high misdemeanor in any state shall flee from justice and be found in any of the United States, he shall, upon demand of the governor or executive power of the state from which he fled, be delivered up and removed to the state having jurisdiction of his offense. So clearly, you can still be subject to the laws of the state as a free inhabitant. So, even if the Articles of Confederation were law, which they're not, and even if you were an Article 4 free inhabitant, you're still subject to the laws. You still have to have a driver's license, you still have to listen to the cops, you still have to respect law. So in this case, sovereign citizens are completely wrong. Thank you very much for listening to this episode of A Bit Too Much to Think. If you liked it, leave a like. If you have some more thoughts on this subject, leave a comment. I love reading those comments and seeing what you guys think about this subject. Please subscribe if you're interested, and have a wonderful day.